M. Kimmerite, Chair of the North Carolina Utilities Commission. And with me this morning are Commissioners Jeff Hughes, Floyd B. McKissick Jr., William M. Brawley, and Stephen J. Levitas. I now call for oral arguments hearing in docket number A-41 sub 24 in the matter of request for determination of regulatory requirements and request for initiation of audit, which I will refer to as the complaint going forward, regarding parking operations and specifically the increase in parking rates. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has a known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. Before the Commission is the Village of Bald Head Island, which I'll refer to as the Village. The Village's verified complaint, request for determination of regulatory requirements, and request for initiation of audit. And I'll refer to that also as the complaint regarding parking operations and specifically the increase in parking rates. The complaint seeks an order from the Commission, number one, finding that Bald Head Island Limited LLCs, and I will refer to Bald Head Island LLC as Limited or BHIL, unilateral notice of parking rate increases was improper and should be rescinded. Number two, requiring the submission of additional financial and operating data concerning parking. And number three, requiring the public staff to conduct an audit of Bald Head Island Transportation Inc.'s, that I'll refer to as Transportation or BHIT, consolidated operations, including parking. On February 17, 2025, BHIT and Limited, which I'll refer to collectively as the defendants, filed a response to the complaint, motion to dismiss, and request for declaratory ruling, or in the alternative, motion to consolidate, which I will refer to as the response. On March 3, 2025, complainant filed its reply to defendant's response, motion to dismiss, and request for declaratory ruling, or alternatively, motion to consolidate, which I'll refer to as the reply. On March 17, 2025, defendants filed a request for oral arguments. Defendants requested that the Commission schedule oral arguments of counsel on the legal and policy issues raised by the complaint, the response, and reply prior to issuing any scheduling order, allowing discovery, or otherwise proceeding in this docket. On March 24, 2025, complainant filed a response to request for oral argument, which I will refer to as response to oral argument request. In the response to oral argument request, complainant requested that the Commission first allow a briefing on several threshold legal questions prior to scheduling any oral arguments in this matter. On March 28, 2025, defendants filed their reply to the response to request for oral arguments, restating their request for oral arguments. On April 15, 2025, the Commission issued an order scheduling oral arguments to be heard today, May 6, 2025, beginning at 10 o'clock a.m. at this location. As a reminder, the Commission's order directed the parties to present their oral arguments in the following order: the Village, followed by the defendants. The parties were further directed to limit their prepared remarks to 25 minutes each, although the Village will be allowed an extra 5 minutes for a total of 30 minutes to make a brief rebuttal. Commissioners will be given the opportunity to ask questions at the end of each party's oral argument, and commissioners may also ask questions during the party's oral arguments. However, the commissioners will attempt to refrain from asking questions during the oral arguments because we will be carefully monitoring the 25-minute time limit. So that brings us to today. I now call upon counsel for the parties to announce their appearances for the record, beginning with the complainant.
Good morning, Chair Kimmerite. I'm Marcus Trathan with the law firm of Brooks Pierce, appearing on behalf of the Village of Bald Head Island. With me are my colleagues, Sam J. Urban IV and Amanda Hawkins.
Okay. Good morning, Mr. Trathan.
Chairman Kimmerite, member of the Commission, my name is Ray Sires, the law firm Fox Rothschild, and I have with me my colleague Liz Hedrick, and we're here on behalf of Limited and Transportation.
Okay. Good morning, Mr. Sires. Are there any preliminary matters that need to be addressed before we proceed with the oral arguments?
No.
Okay. Okay, none from the defendants either? Okay. Okay, since we have no preliminary matters to be addressed, we will proceed with oral argument, beginning with the complainant.
Chair Cameron, members of the commission, as Mr. Tratham has previously indicated, I'm Sam Irvin IV of counsel with Brooks Pierce, appearing on behalf of the village of Bald Head in this case. Appreciate the chance to be here with you this morning and to talk about these important issues, and appreciate and look forward to your questions when they come. At least as we see it, there are two principal issues before the commission today. The first is whether the commission has jurisdiction over parking rates at the ferry terminal at Bald Head Island. We believe that the Court of Appeals, in affirming this commission's sub 21 order, definitively answered that in the affirmative. We also believe that they made that decision on the basis of the very facts that really are not in dispute in this case. And so it's our contention that the decision of the Court of Appeals is controlling with respect to the first of these two issues, but we'll discuss the second as well. In order to decide the matters that are before you in this case with respect to the first issue, you got to just simply take a close look at the Court of Appeals decision in this case. And the relevant part of that decision begins on page 26, and we have submitted in the notebook that was handed up a copy of the slip opinion in this case. It begins on page 26 and continues through page 33. One of the few things that does not appear to be in dispute in this case is that there's no question that the commission has jurisdiction over the ferry and the tram operations at Bald Head, and that's pursuant to GS 62-3A4, which 23A4, which provides that the term, quote, public utility encompasses, quote, any person transporting persons or household goods by motor vehicle or other form of transportation to or for the public for compensation. The issue before the Court of Appeals in reviewing this commission's sub 21 order was whether the commission's jurisdiction under the facts of this set of circumstances extended beyond the ferry and the tram and went beyond that to the parking facilities. Now, the commission in its sub 21 order exercised that jurisdiction based on two statutes. One of them was GS 62-327, which is the ancillary service statute. The other is GS 62-323C, which is, for lack of a better word, the parental authority statute. The Court of Appeals held, and we make no pretense to the contrary, that the commission erred by asserting jurisdiction over parking based on the ancillary service statute. And that issue is not before the commission today. I would note that some of at least one portion of the language that my colleague and friend, Mr. Stires, relies on comes from the court's discussion, not of the parental authority statute, but the ancillary service statute. You've got to focus specifically on the language that looks at the parental authority statute in order to decide this case. The Court of Appeals reached a different conclusion with respect to GS 62-323C, the parental authority statute. It provides that the term public utility includes, quote, all persons affiliated through stock ownership with a public utility doing business in this state as a parent corporation or a subsidiary corporation to such an extent that the commission shall find that such affiliation has an effect on the rates and services of such public utility. In other words, you go beyond the corporate entity to look at a parent to the extent that that parent's activities affect the rates and services of public utility. This commission found that there was an effect associated with parking facilities owned by BHIL on both the rates and the service, and therefore exercise jurisdiction over the parking facilities on the basis of this parental authority statute. The Court of Appeals explicitly affirmed that decision. The idea that the court precluded jurisdiction, it seems to me flies in the face of that specific holding. There's no question BHIL, which operates the parking facilities, and BHIT, which owns and operates the ferries, have the necessary affiliation through stock ownership under the statute. That doesn't seem to have been an issue. I was not a participant in the sub 21 case, but I've read a lot about it, and that doesn't seem to have ever been an issue. What was at issue before the Court of Appeals was whether the commission erred by finding the necessary effect on rates or services. And the Court of Appeals, in the pages that I indicated, 26 through 33, explicitly upheld in some detail the commission's assertion of jurisdiction over the parking facilities under the parental authority statute. First, they went through the commission's determination that there was an effect on service, and they pointed to facts that the commission found, said those findings were supported by sufficient evidence, that the parking facility was necessary to serve ferry customers. They pointed to findings that said it had been built to address specific customer concerns. They pointed to findings that said the loss of the parking facility would significantly impair ferry service. They pointed to findings that there was no viable way to use the ferry service without using the parking facilities. And they found that the use of the ferry service was derivative of and necessary, the parking service was derivative of and necessary to the use of the ferry service. As a result, the Court of Appeals held at page 30 of the slip opinion, and I quote, "The record, quote, provides competent material and substantial evidence to support the commission's finding that BHIL's parking operations, which operate as a de facto monopoly in support of BHIL's subsidiary, have an effect on the adequacy and practicability of BHIT's regulated ferry operation services." So they specifically found that the commission did not err by finding an effect on service. They could have stopped there, but they went on to address the commission's finding determination with respect to an effect on rates as well. And they upheld the commission's determination that the availability of the parking service affected ferry rates too. And it did so based on findings that the parking facilities facilitated greater use of the ferry so as to increase ferry revenues and therefore affect the rate-making formula, which we're all familiar with. And secondly, it found or upheld findings that the parking facilities subsidized the rates for ferry services and the losses that BHIT sustained through the provision of ferry services. Based on upholding those findings, which the commission made and which the Court of Appeals found had sufficient evidentiary support, the Court of Appeals held at page 33 that, quote, "The evidence supports the commission's finding of fact that the parking operations of BHIL, BHIT's parent corporation, impact the rates or service of the regulated utility, and in turn, its, quote, conclusion that BHIL's parking operations are subject to the regulatory authority commission within the confines of GS 62-323C. Thus, the Court of Appeals further held that, quote, "The commission did not err in concluding on the record before us that the relationship between the parent BHIL through its parking operations and wholly owned subsidiary BHIT through its ferry operations affects the utility rates and services of the utility such that BHIL may be subject to the commission's jurisdiction within the narrow confines of GS 62-323C. No matter how many times somebody may argue that there is no commission jurisdiction over the rates and service for parking, the Court of Appeals explicitly affirmed this commission's decision that such jurisdiction existed. Moreover, it's well established under North Carolina regulatory law that an appellate judicial decision, not a commission decision, but an appellate judicial decision, has res judicata effect on the parties. They're bound by that decision, and the parties here are identical, or both were part of it. It's binding upon those parties and is controlling authority for purposes of the commission's decision. And among the cases that hold that are the Utilities Commission versus the Public Staff at 322 North Carolina 689 and Utilities Commission versus Thornburg at 325 463. Thus, the Court of Appeals decision, at least in our opinion, precludes the commission from revisiting the issue of whether the parking facility is a public utility subject to 62-323C, unless perhaps there was some attempt to make a showing of changed circumstances, but there has been no attempt to make such a showing here. And so it is our contention that the commission is bound by that decision and that it is bound to exercise jurisdiction over the parking facilities, including the rates. Moreover, the commission's been exercising that authority for years. This is not anything new. In the 2010 rate order, the commission limited parking rate increases to the rate of inflation. Admittedly, that was part of a stipulation, but the commission did that. They approved the stipulation that had the effect of limiting rate increases. In the sub 21 order, the commission in the Court of Appeals noted this at page 9 of its opinion indirectly, essentially froze parking rates by continuing the 2010 rate order in place. And the language in sub 22 that my friend points to is explicitly conditioned on the closing of the sale to Sharpview, which has not occurred yet and does not say what BHIT and BHIL can do. And the exercise of commission jurisdiction over parking rates makes good regulatory sense as well. The undisputed evidence shows what the Court of Appeals upheld. You got to use the ferry to get to the island. There's no other way to get there meaningfully. Have to use the ferry terminal to get there. No public transportation to the ferry terminal. No other parking lot. Essentially, the use of parking is for most people necessary to use the ferry. And this record in one of the earlier cases said there are more than 700,000 ferry trips. Now, admittedly, that can be more than one person, so I don't want to overstate that. But get that number of trips a year. And if you look at the way the rates are structured now, parking charges for a week exceed the ferry charges. It's clear beyond contradiction that the parking facilities and the ferry and tram are part of a unified whole and that both are subject to monopoly control. And so further, the commission knows why we have regulation. One of the classic examples is in the general telephone case, which is at 281 North Carolina, and this is at page 335. Quote, an uncontrolled legal monopoly in an essential service leads normally and naturally to poor service and exorbitant charges. The customers of the parking facility and the passengers on the ferry, and that's essentially the same group, they're one and the same group of people, cannot be protected from monopoly power that exists without some sort of control over both sets of rates. Now, we all know that for decades, utilities have attempted to use the corporate form to try to get around the commission's jurisdiction. In language that's been repeated many times, the court said in the general telephone case, quote, the doctrine of the corporate entity may be disregarded where it's used to defeat the public interest and circumvent public policy in the regulation of utility rates. GS 63-323C is the parental authority statute, is simply one way in which the General Assembly has attempted to prevent monopolists from using the corporate form to circumvent this commission's authority. There's nothing weird about this. Now, we would contend that many of the arguments that have been made on the other side, and I assume we'll get into those at some point, really don't directly address the analysis that the Court of Appeals relied on. They talk about things other than what the Court of Appeals actually said, and to some extent make attacks on the village's motives. I would urge you to disregard that and to stick to what the legal issues are before them. Let's not have jury speeches and ad hominem attacks and things like that. The village submits that it has acted in authority in accordance with its legal authority, has done what it's done to try to protect the consumers of the island, and that what the Court of Appeals clearly held in this case should be obvious and should be upheld. The second question is what form the Commission's exercise of regulatory authority over the parking rates ought to take. Now, the Court of Appeals said, and we make no bones to the contrary, the Court of Appeals said, as my friends over there have quoted, that, quote, the parking is regulated, quote, to the extent of its affiliation's effect on BHIT's regulated ferry operations, rates, and service. That's the very thing that the Court of Appeals upheld the commission's finding to have existed. The Court of Appeals has already addressed this issue, and it said that there was an effect on rates and service from the parking facilities. So all the Court of Appeals was doing when it used that language was to say what it had already said, that the jurisdiction of the commission is limited to a situation in which the parking facilities affect the rates and services of the ferry. And a finding to that effect was upheld by the Court of Appeals. It's also clear, if you just want to decide this issue anew, which I don't think you should, but if you want to decide this issue anew, it's clear that the rates for parking affect the rates for the ferry. There's no question that you've essentially got to pay both rates in order to make use of the system. The situation is such that if you increase the rates for one, it affects the overall revenues of the system. And it is possible when you have unregulated parking rates and regulated ferry rates, which have already been established where one subsidizes the other, it's possible to exert monopoly power through parking rates and therefore obtain the kind of exorbitant return on the overall system that the commission is here to prevent.
Excuse me, Mr. Urban?
Yeah.
How do you contend that the specific increase at issue in this case affects rates or services of the ferries?
I would contend that that's a question for an evidentiary hearing. And so, we do not have the information necessary to make a full evidentiary showing at this time. The issue that we think is before the commission in this case is whether the commission has any authority to regulate those rates in the first place. Our friends on the other side contend apparently that there is none. And so the real issue for us and what we're asking you to do at this time is simply to say that you do have the authority that the Court of Appeals gave to recognize that simply giving notice without doing any more isn't enough to indicate to BHIT and BHIL that they need to file an application to change the rates in accordance with the normal commission procedures. And then at that point, we can worry about that. But what we've got here and what we're concerned about is the specific procedure that's used. Can BHIT and BHIL simply by notice without commission authorization come in and do that? And we contend that that's the real issue. And what we're asking is that the commission reiterate that it has that authority. And then in the event that a proper filing is made, then we can decide the question that you asked at the time. The issue here is the principle of does the commission have any authority?
Thank you. I'll save my questions about the procedure till after we finish argument, but just one follow-up.
Sure.
Do you contend that it's sufficient to survive a motion to dismiss for you to simply make a conclusory allegation that there has been an impact on rates or services
Yes.
without any detailed pleading?
Yes, and let me tell you why. Because again, all we are asking is that the normal rate-making processes be followed, and they haven't been followed here. There's been no application. There has been no discovery, no fact-finding. The burden of proof in such a case is on the utility under the statutory provisions. We don't have the burden of proof. They do. And they need to be required to satisfy their burden of proof. And so the answer to your specific question is yes, under this set of circumstances, we filed this complaint for the purpose of making sure that those procedures were properly followed. If they're properly followed, then the issue that you address, and I concede that is an appropriate issue at some point in the proceeding. But I don't think in order to get the commission to exercise its authority, we have to make that showing now. Does that answer your question?
Yes, thank you.
And I have a follow-up question and about the burden of proof. Who has the burden of proof in this particular proceeding? You are the complainant. You have filed the application. Do you have the burden of demonstrating that that the increase in rates that were noticed by the village and transportation is that they should not have done that, that the commission has a jurisdiction and they have to file an application. Where does the burden of proof in this situation lie?
The burden of proof with respect to the justness and I mean, I'm going to answer your question in two parts, and I don't want you to think I'm trying to dodge it, because I think it's a two-part question. The issue of the justness and reasonableness of the rates, the burden of proof is clearly on VHIT, and they have made no effort to speak of in this case. Simply, they filed a notice. Now, in terms of this particular case, it seems to me that the issue before the commission that I've talked about at some length, which is the burden of, which is the meaning of the Court of Appeals decision. I think that's really, not really a matter of burden of proof. That's not an evidentiary issue. The burden of proof applies to evidentiary issues. What we have here is a flat out issue of law. And it seems to me that's one of those things that the commission has to decide based upon its analysis, and that burden of proof analysis, which deals with factual questions, has no bearing on that issue.
And I'm going to reserve my questions about the Court of Appeals decision till you finish your oral argument. But if the commission were to agree with you about your interpretation of the Court of Appeals decision, that what the Court of Appeals was saying is that the commission could assert jurisdiction or authority over not just the sale of the ferry, but also the rates, the parking rates. We'll just assume that's before the commission to determine. But then, isn't it your burden to come forward and demonstrate that that any increase in rates affects the rates and service of the ferry, the regulated utility? Isn't that your burden? And do we have any evidence to proceed in that regard in this proceeding?
Not in this case. Now, it might, in another set of circumstances, if this was up here without having gone to the Court of Appeals first, I'd probably agree with you.
Mm-hmm.
But that's not what we have here. We have a hearing. I mean, we have a Court of Appeals decision, I'm sorry, that says specifically that such an effect existed. That the commission found it, and that decision was affirmed on appeal. That decision is res judicata for purposes of this case. It is binding on the commission. So no, we do not have the burden of proof because the Court of Appeals has already decided that. And the commission is obligated to apply that decision as it is written. And so again, I'm not trying to dodge your question, but I don't think that that issue has already been resolved in our favor. That decision is binding on the parties to this case. There's no showing of any change in circumstances in the underlying facts that the Court of Appeals utilized to make that decision. And therefore, I don't think we have any such showing, because I think the Court of Appeals has already held that that was the case.
And one last question. We're coming to the end of the oral argument time, but
I have no idea where I am.
If the commission were to disagree with you, if we were to disagree and say that the Court of Appeals decision makes a decision only about the how the parking rates affect the regulated utilities, rates and services, that was limited and specific just to the sale of the ferry. If that is the interpretation of the Court of Appeals decision that the commission were to have, different from the last question I asked you, in that regard, who has the burden of proof? And have you provided evidence? Is there evidence before the commission to determine that the parking increase affects the rates and services of the regulated utility?
I don't think that's actually the correct question, Chair Kimmerer. The question is not whether the rate increase affects ferry rates. The question is whether the parking facilities affect the ferry rates. Once the parking facilities affect the ferry rates, then the commission has jurisdiction, then the normal rate-making processes come into effect. So no, we do not have a burden of showing that. Now, we have alleged in our complaint, and I haven't gone back in the last few days and looked again at the admissions and denials in the complaint, but I think we have alleged everything that the Court of Appeals relied on. And I don't think there's been, in terms of factual bases for asserting an effect, and I don't think my colleagues on the other side denied any of them materially. So I think we've got the allegations in there if we have to do that. I
Mhm.
don't think they have been denied. But again, the jurisdictional issue depends upon whether the parking facilities affect the rates and service. That's been held that they did. There's no requirement that there be a showing that a specific rate increase affect the rates and service.
But that's what we're here for today, correct? That rate increase.
The rate increase triggered this filing.
Mhm.
But the reason that we made the filing was a concern that we have an assertion of the right to make a unilateral increase in rates and charges without following the normal commission rate approval processes. And so what we are seeking is an order that that those processes are mandatory, that BHIT and BHIL are required to comply with those processes, and that they have not.
Okay.
And that's all we're seeking at this point.
Okay, thank you. And so the one last question from Commissioner Levitas, and then we will turn to questions from the commission.
Just following up on Chair Kimwright's prior question, isn't it the case that the holding or the ruling in sub 21 that was in turn affirmed by the Court of Appeals related to the generic potential for parking rates to affect rates and services of the ferry? And it didn't go to the impact of any particular rate increase. That's the issue that would be before us in this proceeding. So the fact that there's been prior holdings that there is this generic potential for such an impact doesn't answer the question whether any specific, excuse me, increase would actually have such an unacceptable impact on rates or services, correct?
And with all due respect, Commissioner Levitas, I don't agree with the decision that way. I read the decision to say that there's the first question is BHIT and BHIL is it a public utility or not? And the Court of Appeals affirmed the commission's decision that it was, and that the affirmance was based on the existence of an effect on rates and service. Once that showing has been made, then the normal rate-making processes come into effect. You don't have to show as a prerequisite for the existence of the commission's authority that every single solitary rate increase meets that criteria. That criteria has already been met. You have to show in effect, and I think they have to show it, not us. They have to show that there is no effect on rates and service from the parking facilities at all in order to get out from under it. Otherwise, there was no reason for the Court of Appeals to go through that whole process. If that is the correct analysis, then there was utterly no reason for the Court of Appeals to even reach that issue. It was totally, they just were talking about issuing an advisory opinion. They weren't doing that. Their decision had to have some practical effect. The practical effect is they being BHIT and BHIL, become utilities, and then they're subject to the rules applicable to utilities. There's not a requirement that every single time they raise a rate or change anything, that the showing has to be made that they are a public utility yet again. If that's the case, look at the complexity of the litigation that you're going to wind up with every single time. That's not, I don't think, what the Court of Appeals held.
Okay, thank you, Ms. Urban. We will now turn to questions from the commission, and I'll begin. I know that my fellow commissioners will also have questions. What I'm mostly interested in is the commission's jurisdiction over parking rates, but I'm going to begin with some more general or background questions. So the Transportation and Limited's notice of the increase in parking rates that they provided in November and then put into effect in January. Do you disagree that it matches the rate of inflation, or are you in agreement that it does match the rate of inflation?
Not in a position to say one way or another, Madam Chair. We don't have an evidentiary record upon which to base that. I'll have to say I was a history major and am not a mathematician. I'm not attempting to duplicate the calculation that appears in Mr. Stires' formula or in his filing. But I think that's something that would be subject to an evidentiary hearing at the time. And again, at least as far as the relief that we're seeking in this case, that's something that ought to happen, to be evaluated at a later time and not now.
But I understand your position about that, but in this proceeding, have you presented any information or evidence that it is not consistent with the rate of inflation?
I don't know that we presented any evidence that it isn't. I don't know we don't agree that it's been established that it is because there's been no evidentiary hearing.
Okay. Correct. This is not an evidentiary hearing. I understand this,
That's the one
but
thing
in your,
we all agreed on at the
Right.
beginning of the proceeding, and I want to very much stick to that.
in your complaint, did you allege that, did you take issue or make any allegation that this increase is not consistent with the rate of inflation?
I believe, and I would have to, I don't have a paid citation I can give you and will correct myself when I get a chance to sit back down after I finish. I believe that we did allege that they were not just and reasonable, at least that the increase, that the rates upon increase were not just and reasonable. I believe we allege that. I know it's not an evidentiary hearing, but subject to check.
And the notice of change to Southport parking lot rates was issued on November 26, 2024. And then the rates came into effect or became effective on, I believe, January 1st of 2025. When did the village become aware that it was dissatisfied with the rates or that it was taking issue with the notice filing that was provided by
I
transportation?
don't know exactly, Chair Cameron, it's, we were aware that it had been existed. I'm pretty sure we were aware before the 30-day deadline that you mentioned. I'm not trying to quibble with you about that, but I don't know the exact date.
Mhm.
I suspect we have it, I just don't know it.
Okay. And why did the village wait almost 2 months? I think that the complaint was filed on January 27th of 2025 to file the complaint. Why did it take 2 months to bring this to the commission's attention?
Again, I'm now speaking perhaps on incomplete knowledge. And so I don't want to be understood as not doing that.
Mhm.
I think the question that we had to ask, well, first of all, there are some municipal procedures that you have to follow. And I was not, to the best of my recollection, involved in those in any detail, and I cannot tell you what they are, but you've got some ability, you've got some things, hoops you've got to jump through, as you probably know better than I do, before a municipality can take action. More importantly, as I've said a number of times, the issue is, in our opinion, really is what is the commission's authority? And we had to think through what is the best way to ask the commission to assert that authority. We had to, as you can see, the drafting of our complaint was not a short document. And so that took some time to put together. This is an issue that we thought deserved serious consideration on our end before we raised it here. And again, our principal issue was whether BHIT and BHIL could raise rates unilaterally without the commission's involvement. And that's what we were focused on, and that's why it's couched the way it's couched. I hope that's something of an answer to your question at any rate.
Yes, thank you.
It's probably the best I could do.
Thank you. And in your complaint, there was a statement or allegation that stated that this matter could have been avoided if BHIL or BHIT had involved the village and other stakeholders in this process. Is that correct? And can you elaborate about why you say that just involvement in the process could have avoided this litigation in the complaint?
To the best of my recollection, and I think, again, I don't have that particular language right in front of me, so I'm flying on my 69-year-old memory. But my belief that the point that was being made at that part of the complaint was to say, in essence, this is an action that was taken unilaterally by BHIT and BHIL. We are always happy to talk with them about it. That didn't happen, is my understanding, in this particular instance. Whether there could have been some constructive dialogue about it, either about this specific issue or about the broader issue that Mr. Stires in his response admitted that the commission's got to deal with at some point, unless you take the position that the commission has no authority here at all, which is what are the procedures to be used. I think that's perhaps, aside from the applicability of A4, the other thing we agree on is that there's a need for the commission to do that. What we meant by that, in essence, was this was an instance in which BHIT and BHIL handed us essentially a fait accompli. We didn't talk about it ahead of time. It might have been productive to do that. You know, we don't know, because there's been no evidentiary hearing, what cost increases they may have incurred, whether, to go back to your earlier question, whether in fact the rate of inflation is an accurate depiction of what the cost of providing parking service is, to the extent that that's relevant to this particular issue. There's a lot we don't know. Had we had those discussions, we might have been better informed and might have been able to work out some kind of resolution with them, but that's not the way this went down.
Mhm. And then, does the village seek a declaratory ruling pursuant to the North Carolina Declaratory Judgment Act, which is North Carolina General Statute Section 1-253? Is that the statute that, or the authority that you're proceeding under in this proceeding?
That, and the fact that the commission generally has a right to determine whether the rules and regulations applicable to regulated utilities have or have not been complied with. I think that's inherent in the authority that's available to any, to this body. You are supposed to regulate the rates and services of utilities. That means to me that you've got the right to make declarations. You can issue rules. You don't have to just sit back and wait for somebody to do something. You have the ability to make declarations that hopefully will make it easier for the parties moving forward to do what they're supposed to. So I think it's both. I think it's the commission's inherent authority and the Declaratory Judgment Act. And again, the Court of Appeals in this case held that the commission had the authority to make a declaration of whether BHIT and BHIL were subject to the commission's jurisdiction with respect to parking.
Thank you. I'm now going to turn to, I think, what is the critical issue in the case is how the Court of Appeals decision is to be interpreted.
Okay.
And you talked about res judicata, about the Court of Appeals decision. And is it your position that the Court of Appeals decision that the issue before us about the commission's authority and jurisdiction, that the Court of Appeals decision controls in that regard, or is the sub 21 order controlling, or both? What is are we to look exclusively to the Court of Appeals decision on this issue?
I think again, I feel like I'm quibbling with you all the time, and I don't mean to, but what we look to is the sub 21 order to the extent that it was affirmed by the commission. And so the sub 21 order is what was affirmed by the commission. I mean, by the Court of Appeals, I'm sorry. And so that decision, and the decision specifically that the parental authority test was met, you mostly look to the decision of the Court of Appeals. In terms of the second question that I posited when I started, I think the sub 21 order becomes relevant because at that point, the commission took some steps to decide what, in the exercise of its parental authority, it was going to do. So at the second stage of this process, I think it's where the sub 21 order particularly comes in as being relevant. So I think both of them are relevant. There's no question about that.
Mm-hmm. And so what I want to focus on is a Court of Appeals decision.
Okay.
And the Court of Appeals decision, I'm going to start with page 34. And where I'm going with these questions is essentially, and I want you to help provide me your position about this, but the Court of Appeals decision states very specifically that HBIL, which would be we'll just refer to transportation or limited at this point, may be regulated merely to the extent that its parking operations impact the rates or services of BHIT's ferry operations. But the discussion by the Court of Appeals relates exclusively, from my reading, to the sale of the ferry. And there is no express discussion or determination that the commission has authority to regulate the rates of transportation, transportation or limited. And so I'm going to start with, let's see, let's begin on page 26. And
Give me a second to get the.
right, page 26 of the Court of Appeals decision. And let me know when you're there.
Page 26.
Okay. And this is the last full paragraph. And the Court of Appeals states that there was evidence that the operations of BHIL impact the rates or services of BHIT. And this is the quote, such that the circumstances of that relationship subject the sale of BHIL's parking operations to the commission's regulatory oversight. And then moving on to page 33. And let me know when you're on page 33.
On page 33.
Okay. And I'm going to begin halfway down the last full paragraph where it states that we cannot affirm the commission's sweeping determination that the parking operations are subject to the commission's jurisdiction and regulatory authority without emphasizing that this authority extends only as far as BHIL may be considered a public utility because of and only to the extent the effect that the parent company BHIL has on its subsidiary company BHIT's utility rates and services. To hold otherwise, we could create a dangerous precedent and allow for unbridled commission authority over the otherwise free market principles of our economic system. And the commission goes on with additional information. And then on the next page, it says the BHIL may be regulated as merely to the extent that its parking operations impact on the rates or services of the ferry operations. And then finally, on page 34, the last full paragraph, it says, we affirm the commission's order as modified in this opinion as to the parking operations and uphold that BHIL shall not sell, assign, pledge, or transfer the parking operations without prior commission approval. And I'll be asking the same sort of questions of Mr. Stiers, but I see nowhere in here where the Court of Appeals specifically states that the commission has authority to regulate the rates of the parking operations. It seems to me that the discussion relates specifically to the commission's authority over the sale of the ferry.
And this goes back to why your question earlier was good about the effect of the sub 21 order.
Mhm.
If you will recall that the sub 21 order contains a specific provision requiring commission approval prior to sale or transfer of the parking facilities. It was a specific ordering clause, as I recall, that said that. And every time you see that language in this referenced in this decision, what it's doing is it is affirming the authority of the commission over BHIL and BHIT, the parking facilities, and affirming that particular decision. That is not a statement that it is only that the only commission authority has to do with the sale and transfer. Look, for example, at what it's doing is over several times says that the commission's decision is upheld, including, but not limited to, that particular provision of the order. Look, for example, at page, it was the meeting of the paragraph above. The BHIL may be regulated, the last sentence in the preceding paragraph on page 34, and I offer this up not as an example. May be regulated merely to the extent that its parking operations impact on the rates or services of BHIT's ferry operations. There's no limitation to the transfer there. It just simply says if you can regulate it to the extent that it has an impact on the rates and services. There's no, just as there may be no specific point blank explicit statement that you can regulate rates, there's also no explicit point blank statement in here that says that the commission's regulatory authority over the parking facilities is limited to control of the transfer. The reason that rates are encompassed in that is because by finding it to be a public utility, it is then subjected to the commission's authority over public utilities, which includes primarily rates and primarily service, but also approval of transfers. And so I don't think that the Court of Appeals decision limited the commission's authority to approval of a transfer. It says VHIT and VHIL is a utility, and once you do that within the confines of the criminal authority statute, which also does not speak to only a transfer, then I think you've got your authority over rate regulation.
And can you point in the order where it states, when you talk about being a public utility, where the parking operations are a public utility? In the Court of Appeals order, is there anything,
Sorry, I went to the order from
Right.
the now.
right, I want to, basically, I want to know specific,
My bottle cap.
Yeah.
An example. VHIL may be regulated to the extent that its parking operations, services, and VHIT's very operation. You can regulate it to the extent that it affects rates and service. The rates for parking, as we previously said, affect the rates for ferry service. Therefore, you can go back and regulate to an extent that the commission, which has not yet made this decision, deems appropriate, subject to whatever the legal ramifications, legal rules are. And I don't want to
Mhm.
take our time to go there.
Yeah.
Well,
Well, let me ask about the better question. Does the Court of Appeals, anywhere in the Court of Appeals decision, does it expressly state that the commission has the authority to regulate the rates of parking? Is there anything specific in there? I couldn't find it. But I think that's your position. If there's something that the Court of Appeals states, could you point it to the commission?
It says that by virtue of the fact that it finds BHIL to be a public utility under the parental authority statute. Once it becomes a public utility, its rates and its service are then subject to the commission's jurisdiction. You don't have to say that. That's implicit in an assertion of the commission's regulatory authority. The fundamental guts of the commission's authority are authority over rates and service. If we start having to say every court of opinion's got to specifically enumerate what the specific regulatory authority is, there's no reason to have a definition and to have the basic statutes that govern the commission's authority. So again, by virtue of finding it to be a public utility, you have then been given authority over rates and service.
And I'm going to move on because I imagine that my fellow commissioner has some questions, but this deals with the argument that was made in the complaint about that Limited did not have the, was violating the stipulation and settlement agreement by increasing the rates by the rate of inflation. But the agreement and the stipulation, the regulatory commissions, the regulatory conditions.
So I don't get lost. There's several stipulations in the record here. Which are we talking about? The one in sub 22?
The sub 20, we're talking about the sub 22 stipulation and settlement, and there were regulatory conditions, and they expressly stated that the regulatory commissions would become effective upon the sale of the ferry, and the sale has not occurred. So, so do you agree that? What is your position? Are they bound by those regulatory conditions since the sale has not occurred?
No. Not only that, what our position is that they are subject to the provisions of North Carolina law, and that this stipulation doesn't become effective until the transfer is closed, if it is, and therefore it does not create an affirmative right, particularly on the part of VHIT and VHIL, to do anything with respect to rates, because the stipulation gives that authority to Sharpview, and it's I get confused here, BHIFT.
Mhm.
So I don't think it has any real bearing on this outcome of this case.
Okay, thank you. That's all the questions I have. Let me check with my fellow commissioners. Commissioner Levitas. Oh, I'm sorry, excuse me. Okay.
Uh, Thank you. So let me start with this issue that Chair Kemmerite's been pursuing. I don't think you contend, it's hard to know whether you contend, so let me ask. Do you contend that,
So I'm sorry,
That-
it's hard to know.
that
What
the-
we're pretending that's not, that
well,
doesn't make
well,
me feel good.
you've repeatedly referred to a holding by the Court of Appeals that parking is a utility, and that answers all the questions. But under I think you call it parental control statute, the 62-323C, the way in which affiliated entities that are brought under our jurisdiction are regulated is not the same way as other utilities, statutorily enumerated utilities, right? It's a limited jurisdiction, both in statute and in the Court of Appeals ruling.
I'm going to disagree with you, but I think we may be talking past each other, and I want to acknowledge that up front. There are more than one way for the affiliated relationship to be affected by commission decisions. One that we've not talked about in this case, but it does apply in some affiliate instances, is 62-153 dealing with affiliate contracts. Another statute that was involved in this litigation before the Court of Appeals was the ancillary service statute. That's another way it could conceivably come up. Parental authority is one of the ways that relationship can be governed, but it's by no means the only one. It's the one that's applicable here.
Well, let me rephrase my question.
And that's why I
Make
was
another, I'll
afraid
make
I was
another
talking
run at it. Do you contend that we have the authority to regulate the rates and services of parking without regard to their impact on the ferry service, in the same way that we have the ability to regulate the rates and services of the ferry itself?
I contend that you do until a showing has been made that the conditions that led to the Court of Appeals decision, which basically had to do with the monopoly nature of the parking service and the fact that there were no meaningful alternatives to its use, until that doesn't exist anymore, then yes, I think you do.
So
If
I'm going to ask it again.
If at some point BHIL and BHIT want to come in and make a motion that there be a new declaration based on changed circumstances, I think they could do that, but they've not done it.
But are you suggesting that we have the ability to look at the parking rates and determine whether they are just and reasonable, standing alone, without regard to any impact on the ferry service?
I'm going to give you a two-part answer to that. The first is, yes, I think you have that authority. The second is the commission in the sub 21 order specifically disclaims, stating specifically how it was going to exercise that authority. The commission, to my knowledge, has never made that decision. And I think in the event that the BHIT and BHIL did, which we put on application, that's an issue that would need to be addressed at that point in the proceeding. So I'm not saying that the only thing that the commission can do is establish a specific point, single monetary amount rate for parking. I'm saying that they have to come in and get approval to charge it, but the commission has a range of regulatory options, and we're not saying those options don't exist.
Well, let me turn to a couple of things in the Court of Appeals order that maybe help you, although I think they're more consistent with my view than with yours. But looking at the top of the page 23, because your response to Chair Kemmerite was that her answer was that the Court of Appeals ruled that parking was a utility, and that's the source of our authority. But if you look at the end of that first partial paragraph on page 23, what they found was they effectively affirmed our conclusion, commission's conclusion, that limited parking operations are subject to the commission's regulatory authority, right?
Correct.
And that's helpful to you.
Because the parking operation.
Within the confines of the statute. And then they go on in the very next paragraph to go to great pains to limit what the extent of that authority is, right?
Well, they are obviously, and I understand why. They are obviously trying to make sure that the commission does not get the idea, which I don't think it does, or did at the time, that it has any kind of broad authority over BHIL's operations in general. And it's making BHIL does all kinds of things other than provide parking. And I think repeatedly they say, because I think they're understandably concerned, some of the language that the Chair Cameron pointed us to earlier is a reflection of this. They are trying to make sure that the commission not overstep its bounds, but they do clearly say that you have jurisdiction over parking because of the impact on rates and service. You do have jurisdiction over parking.
Let's talk about rates and services. So as you pointed out, those are two different things, and the Court of Appeals dealt with them differently. And I asked you earlier about your views about the degree of specificity that might be needed at this stage of the proceeding. But let me ask you some specifics about how those mechanisms may operate. Maybe I'll take services first, because I think that's maybe the simpler one. But there, as I understand it, the idea that's been discussed is that because of the configuration of the parking arrangement, the only way to get to the island and so forth, that if that it's possible that the services of the ferry could be adversely affected because people wouldn't have the ability to use it, right? And again, I asked you, maybe you answered it, but are you contending or alleging any specific impact of that sort in this case, that from this rate increase has caused people to be able to use the ferry less, or the workers can't get to the island or anything of that sort?
Again, subject to check, Commissioner Levitas, I don't remember an allegation in the complaint that says that. I don't have the entire 40-page document committed to memory, but I don't believe there is any such allegation.
Okay, well, and turning to the rates, I may not be thinking about this right, but I thought about two things on the rates issue, and they're very different things. One is, and it's discussed in I think it's in the sub 21 order in the Court of Appeals and in your papers, this idea that if the parking rates were sufficiently high, that would adversely affect ferry ridership, and that the ferry would potentially then in turn have to raise its rates. That's one type of impact that parking rates could have on ferry rates, right?
That's one of the impacts that the commission found in the sub 21 order that the Court of Appeals relied on in affirming its decision to exert authority.
Right. And again, are you alleging that type of impact is occurring here with this rate increase?
We have generally alleged that these rates are not just and reasonable. We have not made that specific allegation, as best I can recall, with respect to this rate increase.
Okay. And then the other type of rate impact, which is this idea of cross subsidization.
Right.
And in that case, the rate increase in parking is not going to cause regulated rates. It's not going to cause the ferry rates to be too high. It may help them stay low. I think that the issue would be that if the total, you'll talk about the rate of return or the profit margin of the combined enterprise being high and suggesting that it's perhaps unreasonably high. It seems to me that the solution in that case, the remedy in that case, is not to lower the parking rates, but to require a greater attribution of parking revenues to the ferry. And if so, what is the proper procedure for doing that? If you said, hey, what's going on here is they're not attributing enough revenue to ferry, what would be the procedural mechanism to address that?
I think there's several procedural mechanisms that could affect it. The most obvious is to have a general rate case that sweeps in everything. And you can then do what the Supreme Court upheld in the Nantahala cases, which is something like rolled in rate making. one of our concerns, very honestly, is that if there is an unfettered right on the part of BHIT and BHIL to do anything they want to with respect to parking rates, it seems to me that calls into question the validity of the imputation process that's been utilized for the last decade and a half. That was the result of a stipulation. As I recall, BHIT and BHIL reserved the right to object to it at a later time. And so one of the fallouts of accepting the argument that has been made here may be that the ability to do imputation goes away. That's one thing you could do. I've repeatedly tried not to get into what specific form the regulation ought to take, because I think that takes an evidentiary record that we don't have. But I think that's one thing you could do.
Mhm. Excuse my ignorance on this question, but do you have the ability to petition us to initiate a rate case?
I think any customer has the right to request that at some point. I'm not sure the commission would want us to do that, given the complexity of these cases and the way that the contentiousness with which they have been dealt with in the past. And so is that something that has crossed the village's mind? Mm-hmm. It has. But is that the best way to deal with this problem?
Well, let me shift gears a little bit. It may take us back to the same place. You repeatedly assert that criticize Limited for having unilaterally initiated this increase. What do you contend is the source of a legal prohibition on on Limited, quote, unilaterally raising rates?
The most obvious one is the sub 21 orders limit on basically freezing the rates.
Yeah, you say that let me look at your response. Say. Bear with me for a sec. Yeah, at page 21 of your.
Page 28, but I'll turn to page 21.
Yeah, you say it in the middle of page 21 that in the meantime, the commission ordered, quote, the status quo in the current rates and services to continue. Is that what you were referring to?
Primarily, my notes, I'm referring primarily to page 28.
Yeah, but sorry, it's page 28 of the sub 21 order, and I was referencing where you cite that page 28 in your
Yeah.
But I don't read the sub 21 order that way. I think the sub 21 order was blessing the status quo, but not prohibiting, not establishing a prohibition on any changes to the status quo.
Well, and if I said that, I misspoke. What I meant to say, and evidently did not say, is that it freezes the status quo until such time as a proper application is filed. And at that point, I mean, nobody's saying they can't apply. The question then becomes, what do they have to do in order to do that? That's not what's happened here. They've got to invoke the commission's authority and seek change rates, and they've not done it.
Well, you're seeking a declaratory judgment as to, and I think the parties agree that are asking the commission to articulate the appropriate procedures for dealing with parking rates. What do you contend the appropriate procedure should be?
Well, I'm going to answer it a little bit differently, and I'm going to acknowledge that I'm doing that. What we contend ought to happen here is that the commission should enter an order that declares that it does in fact have jurisdiction under the Court of Appeals rates under the Court of Appeals decision on over parking rates. It should then indicate that the BHIT and BHIL cannot simply file notice and be done with it. that they instead have to apply for a rate increase to the commission. Then if and when they file such an application, our contention is that at that point, it should be handled in accordance with the commission's ordinary rate-making processes. We talked a little bit about that. I don't want to, specify a particular way to go about it because I think you'd need an evidentiary record in order to do that. And that's what we think ought to happen here, coupled with our request that the audit required in the 2010 rate case be ordered and that the quarterly reports, the annual reports that are filed include some information about parking. That's what we're asking for.
Okay, that's all I have. Thank you.
Thank you.
Commissioner Brawley.
Thank you, Chair Cameron. Morning, Your Honor.
Good morning. How are you doing?
I'm doing well. You did say the rates were not just and reasonable, but only because they had not been ordered by the commission. On page 2 of your filing, you said, although the village acknowledged the rate increase at issue here are modest, they're being imposed contrary to direction of commission without justification. But your pleading went on to say, the need for this proceeding might have been avoided had attempted to work with stakeholders to explain the need for the rate increases, provide assurances regarding the use of the funds derived from the new rates, the potential need for additional future increases and other measures, but instead had chosen the path of unilateral action, thus necessitating this filing. Doesn't that imply that the village wanted to exercise the power it's now asking the commission to exercise and give permission for the rate increase or to control it?
We didn't. I don't believe we intended to ask that the rate increase be approved. If I've understood what your question, and I may have missed.
Could you pull the microphone a little bit closer to you? I think some in the back are having trouble hearing you.
Okay, and I apologize for that. I have a tendency to wander, and I regret that, but appreciate the reminder. I don't believe, if I understood your question correctly, and I may not have, Commissioner Brawley, and if I didn't, please give me another shot at answering it. But we certainly did not suggest that we thought that the rate increase was just and reasonable, and we did not suggest that we were trying to put that at issue here. We were trying to get the commission to exert authority and to have proper procedures followed. That's what my understanding, at least, of our effort, or the purpose of our effort was.
So would that mean that the sentence, the need for this proceeding might have been avoided, really had no meaning and isn't true because regardless of the conversations they had, the village would contend that without a rate hearing that those rates could not go into effect?
No, I don't think so at all. And if I gave you that impression, I misspoke. The reason that language is in there is that we would have preferred that Limited and BHIT come to the village, discuss the situation with us, explain why they believed this increase was appropriate, why they thought the cost justified and other factors justified the increase. We don't know how those discussions would have gone on because they never happened. But as I'm sure from your experience at the commission know, frequently you'll get situations where parties initially with divergent positions come to an agreement later or even prior to a filing. And our hope would have been that had those discussions happened, we would have been in a position to agree on the types of procedures that both of us, I think, have acknowledged need to be established by the commission. So we were serious when we made that statement, and our preference would have been that such discussions happened before the rate increase was requested. Maybe they would have been productive, maybe they would not have been, but had those proceedings or those discussions been productive, then we would find ourselves in a very different posture than we do here.
Okay.
Does that answer your question? I'm not sure I did.
Well, I'm not sure there is an answer to my question at this point. You made a statement about the commission's authority and that our ability to rule on the sale of the parking lot meant that it was a utility and that authority was including but not limited to, though that language wasn't included in the order anywhere. I did spend some time looking at the order and where the courts, and perhaps you can help me understand this, that I want to find we could rule on the sale of that parking as was mentioned on page 34. And there were a list of things where we could, in fact, exercise authority. This would be in the second paragraph, beginning in the third line. As to the parking operations and uphold the provisions, shall not sell, assign, pledge, transfer the parking operations without prior commission approval. But on the previous page, it made the comments, we cannot affirm the commission's sweeping determination that the parking operations are subject to the commission's jurisdiction and regulatory authority without emphasizing that this authority extends only insofar as BHIL may be considered a public utility, and goes on, and only to the extent of the effect of the parent company has on subsidiary companies' utility rates and services. To hold otherwise would create dangerous precedent and allow the unbridled commission authority over otherwise free market principles of our economic system, and goes on in the same vein. Wouldn't that tend to say no, that it wasn't trying to expand our authority, but was very narrowly trying to keep us focused on the minimum interference with the parking?
I do think, I mean, I would agree with the interpretation that's embodied in your question, to the extent that I think the Court of Appeals was understandably concerned about not suggesting that the commission go beyond its statutory authority. There's no question about that. If you cannot read the opinion without seeing that concern, it's there. But it does not mean that therefore the commission's authority, to the extent granted by the parental authority statute, is somehow circumscribed. The commission has the authority granted by the parental authority statute. Assuming that the parental authority statute comes into play and the Court of Appeals clearly held that it did and affirmed the commission's decision to that effect, BHIL is a public utility, and its parking facilities, which is the only things that are at issue here, are subject to regulation to the extent that they affect the rates and services of the ferry. The Court of Appeals held that they did, therefore those rates and services were regulated or subject to regulation. But on the other hand, I don't know what all BHIL does. I believe it has other operations, and nobody, least of all the village, is suggesting that those other activities are swept in by this holding. They're not.
Well, as a follow-up to that, they did give us a list of the things related to the parking that we could specifically regulate. Rates was not in it.
I'm not exactly sure what portion of the opinion that you're referring to. If you are referring to the language that's on pages 26 through 33, where the court goes through the findings that the commission made, both with respect to service and with respect to rates, that's not a list of the things that the commission is authorized to do. That's a list of the facts that the commission found that the court concluded had sufficient evidentiary support, and those facts supported a determination that BHIL was a utility. But that's not a limitation on what the commission can do. That's the basis for the commission's authority. I would submit to you that they're two different things.
I think they did establish an authority, but on page 34, we affirm the commission's order is modified in this opinion to the parking operation and uphold its provision that BHL shall not sell, assign, pledge, or transfer the proper parking operations without prior commission approval. They could have put rates in that list,
But
change rates, but did not.
And I would contend to you, as I said earlier, and I don't want to repeat myself, but I'm confident you heard me. That is not a statement of what the sole extent of the commission's authority is. That was a specific provision in the sub 21 order, and they are making sure that they uphold it. But that is not a limitation on the scope of the commission's authority. They're upholding the order, including that. It's because that was, one of the provisions in the order. We affirm the commission's order as modified in this opinion. That's part one. And then part two is, and uphold its provision, that the language that you just read, that we all know what it says.
Yep. All right. Thank you, sir.
A few questions. And I'm going to start with the commission's order that was entered back in 2021.
What we're calling the sub 21 order.
Yes, correct. And on page 28, there was reference made to it earlier, but it reads as follows. As a result and as requested, the commission treats the complaint only as a request for declaration of utility status. The commission does not treat the complaint as a request to initiate a rate proceeding and does not require BHIT or BHIL separately or jointly to file a general rate case at this time. And it goes on to say, without more and absent any requested change, the commission permits the status quo and the current rates and services of the parking and barge operation to continue. How do you interpret that particular provision when it says, and specifically, that it permits the status quo and the current rates and services of parking and barge operations to continue? How are you reading that language? What is explicit or implicit with that language?
What is, to me, is pretty explicit is there was a request, or at least a discussion, in the sub 21 case about whether the commission ought to effectively go ahead and set rates for parking. You were there and I was not, excuse me. You were there and I was not, so I hesitate to say what all's in that record. I've read it, but it's been a while. And so the commission, first of all, disclaimed any intention of doing things like that. Then it said we essentially allow the parking facilities to operate under BHIT's certificate and allow the status quo to continue. And our position is that the status quo is that the parking rate that was in existence at that time is something that can be charged, but that it needs to remain in effect until such time as a lawful rate change is made in accordance with normal rate making proceeding. That's our interpretation of the status quo.
And when you say a normal rate making procedure, in that case, there being some type of filing made in a rate case to determine rates.
An application with a justification for it, yes, sir.
And absent that, there could not be any other changes in rates. Is that?
That would be a prerequisite to a lawful change. Now, as I said in response to Commissioner Levitas, one of the things that would have to be determined, and this is one of the things the commission did not decide in sub 21, is what regulatory structure are we going to use? Are we going to have a single dollar figure? Are we going to have some other approach? And the commission, as you know, has got a range of authority there. You just got to exercise some part of it.
I believe there had been a 2010 case which had basically linked increases in the cost of parking to increases in the cost of inflation, but that ended in 2016, that provision.
That is our interpretation of the order, yes, sir.
So it had been your belief, or is it your contention, that after that expired, increases in parking rates based upon increases in the cost of inflation would have been permitted theoretically?
Well, we have a gray area there between 2016 and the date of the sub 21 order. And so we're not taking a position as to the lawfulness of anything that happened in that time frame, because frankly, the conditions that led to the determination that BHIL was a public utility existed, but no such determination had actually been made. The village has not attempted to litigate that issue. What we are saying going forward from sub 21 order yes, they've got to do what I said earlier.
And I believe it is also your contention that the agreement with Sharpview, and I'm going to your complaint. It says on page paragraph 36, as of this date, the transfer of utility assets to Sharpview has not closed and the regulatory conditions therefore are not yet in effect.
Just to show I can give you a one-word answer, yes.
So none of those provisions that would have limited price increases for parking were in effect at the time that the Court of Appeals entered its decision.
There was no provision of the commission order that, at least in our opinion, allowed for an automatic rate increase within the rate of inflation.
And I believe you, during your oral arguments, you indicated that at this time, the village is not taking a position on whether the proposed rate increases that went into effect were out of line with the rate of inflation. Is that correct?
Well, we contend that they were not permitted by them. And so I guess to that extent, we are saying yes, that they are, not permissible. On the other hand, as I've said a number of times, we think that the extent to which the particular dollar or cents rate increase that's at issue here was appropriate is a matter for an evidentiary hearing, and this is not an evidentiary hearing, and so we're not in a position to take a position about that now.
And I believe that based upon your determination, it's implicit with the finding that parking is a public utility is the ability for the commission to regulate the rates of the parking.
Yes.
And while it might be implicit, it does not require us to do so.
Well, it requires the commission to exercise the authority that it's got. I mean, the commission can't just say, we wash our hands of it. There are various things, as I've said a number of times, that the commission can do in the exercise of its rate-making authority, but it does need to exercise that authority in some permissible fashion.
And if we were to exercise that authority, what would be your thoughts about how that should be handled and addressed?
I'm sorry, I keep interrupting people.
Oh, no, it's fine. Go right ahead. I didn't feel it was an interruption, so go right ahead.
We do not have a specific process to propose today. As I've said, and as Mr. Stires said in his pleading, I think we both agree, at least to the extent that if the commission has authority, that the commission needs to have some kind of a proceeding to decide what those procedures ought to be. But I'm not here today to try to talk you into any particular set of procedures. What I'm here today to try to persuade you of is that you do have the authority and that you need to exercise it in ways that are appropriate under the law.
But that ability to exercise the authority would also include the ability of this commission to have a very limited impact on what parking rates might be, for example, only linking it to the cost of inflation.
Well, I'm not going to stand here today and consent to that. I know that is certainly something that has been done by consent of the parties, at least in the 210 rate order. That's something that could be proposed in such a proceeding, and we'd see whether the evidence supported it. I mean, we're talking about a general rate of inflation. Do we know that general rate of inflation is applicable to the cost of providing parking service? Is there any evidence in the record to that effect? Not to my knowledge. So you'd have to look at things like that. But again, the commission's got various types of rate-making authority, and our concern is more that it be exercised than that we determine right now what form that exercise takes.
So what that methodology would be something that we'd have to determine, and we could look at the acquisition price of the land, the amount of money it took to clear the land, the amount of money it took to put into parking, what the reasonable rate of return might likely be, and then do an assessment based upon what we feel local market rates might be for parking in that area.
And again, there are various things you can do, and I don't have the authority today to sit here and agree to any particular one. But again, our request is that you exercise.
Thank you.
I have one last question. This is following up on questions from Commissioner Levitas about the process and the procedure. And I'm focusing on the Court of Appeals ruling statement or its decision where it states that BHIL may be regulated as merely to the extent that its parking operations impact on the rates or service of BHIT's ferry operations. And Commissioner, I know you've answered this question, but I want to make sure that I'm really clear because I didn't fully understand
What page are you on?
this is page 34 of the Court of Appeals decision.
Okay.
And what is the process for determining? We're in this complaint proceeding. And the process for determining if we were to agree with you that the Court of Appeals decision extends the commission's jurisdiction beyond just determining that Bald Head Island may not sell or transfer the parking operations. If we agree with your argument that this decision allows the commission to have some jurisdiction or authority over the rates of limited over its parking operations. But the Court of Appeals decision states that it is merely to the extent of the impact on the rates or services of transportation's ferry operations. How do we get there procedurally or with process? Because we have a complaint and we have allegations, we have nothing before us, no evidence to determine that in any way that the parking operations have an impact on the rates or service of the ferry operations. How do we get there procedurally?
As I said earlier, you don't have to get there because the Court of Appeals has already made that decision and you're bound by it. They have held that the parking rates and the parking facilities affect the rates and service of ferry service, and therefore that it is public utility. There's no requiring of an additional showing beyond that. That's language in the Court of Appeals opinion. It is intended as part of the Court of Appeals attempt to make sure that the commission not wander into other areas of BHIL's business. But I do not believe that language is anything more than a reiteration of the finding that the Court of Appeals upheld that there is no need for a separate showing each time anybody chooses to exercise regulatory authority over BHIL, that proof of those two facts be made again, as I said earlier. If that's the requirement, then there was no point to the Court of Appeals decision.
And can you, you made a statement about what the Court of Appeals said. Can you take a minute and show me specifically where you're relying upon what the Court of Appeals said in making that determination, that they have already determined that we have jurisdiction over?
Well, they didn't, let me back, I don't want to overstate what I just said, and if I misspoke, I apologize. I'm not saying that they specifically said the issue of whether you needed to make a specific individualized case by case every time your authority is invoked determination of the type that your question suggests. They don't say that.
Mhm.
But what they're saying is that this is a public utility. It is a public utility, but because the parking facilities affect the rates and service of the ferry. Once it becomes a public utility, to the extent that we're talking about the rates and the services of the parking, they've been held to affect it, and therefore you have jurisdiction. There's no requirement, there's no specific language in that order in that opinion that I can find that says you have to make a case-by-case determination each of an impact on rates and services each time your jurisdiction is invoked.
Yeah, and I agree, the Court of Appeals does not say that, but I'm just trying to determine where the Court of Appeals says that they've already determined for a jurisdiction of the commission over the rates of limited parking operations, where they have already determined, where the Court of Appeals has made a determination that those the parking rates affect the rates of service of Bald Head Island Transportation's ferry operations such that the rates of parking should be regulated.
They say the former a number of times. They don't say the second because they don't have to. It's implicit in the determination that it affects rates of service.
Okay, thank you. Commissioner Levitas?
I'm glad we're back on this topic.
I missed the discussion.
Well,
It's been 20 minutes since we talked about it. I'm about to-
You were a history major, I was an English major. And I think some of the problem arises from the very specific wording. I didn't have the statute in front of me before, but I do now if I can find it again. 23C. What do you see? It's interesting, the statute uses a different phrase than the Court of Appeals decision, at least in several places. What it says is that the term public utility includes all persons affiliated or et cetera, not to the extent, but to such an extent that the commission shall find such affiliation has effect on rates and services. And so I'm now coming to understand your position a little bit better in that your contention is that there's no sort of intermediate status. Either you're a public utility or you're not. And to such an extent that that an affiliate has an effect on rates or services, it becomes a regulated public utility.
Correct.
And I didn't really understand how you got there.
So I apologize. That's exactly what.
But before seeing that phrase, as I say, it's a different phrase than what's in the Court of Appeals decision. Also kind of helpful to your position, the Court of Appeals at page 34, and this was a point you were making earlier, gets to the idea of different enterprises conducted by the same entity. And I hadn't really focused on that sentence, which they make the point that BHL may be regulated. However, any enterprise, this is your point, conducted by BHL, which is not within the limited scope, is not regulated. I think that's all helpful to your cause. However, the Court of Appeals, as I said, then uses language different from the statutory language. And we ultimately, as you ably pointed out, we're bound by the Court of Appeals decision. Back on page 33 says that it's considered a public utility within the BHL, within the meaning of the statute because of, and then they put this in italics, and only to the extent of. So they're limiting, I'm sorry, I should read on, only to the extent of that there's an impact on rates and services. That suggests that it's some sort of limited jurisdiction. And then before the enterprise language that I quoted, they say that BHL may be regulated. I think they left some words out. They say may be regulated as merely. I think they mean to say as a utility, merely to the extent that its parking operations impact rates or services. Again, it's not the statutory language. It at least is open to interpretation that there is some sort of limited regulation light, as some people have called it. And I think that's the question we're going to have to grapple with.
And I think you are, but I would point out that what's been upheld is the assertion of jurisdiction under the statute. And the statute, as I've said a number of times, creates public utility status once they're a public utility. That determination has been made until the showing of changed circumstances has occurred. And until then, they're subject to rate and service regulation.
Thank you.
We've had you up here for quite some time, Ms. Irvin. Thank you for your oral argument. And we will take a 10-minute break and come back on the record at 11:50 and begin with oral argument from the defendants. We'll go off the record. Okay, we'll go back on the record and we'll hear from Mr. Stires.
Thank you, Chair Kemmerite, members of the commission. Let me say that you have notebooks in front of you, which included some duplication of what the village provided to you. It provides the Court of Appeals opinion at the very beginning, and then there's the documents that are in this case, and then we also had the sub 22 order at the very end. I'll refer to that at part during my argument, and I'll also note that the Court of Appeals opinion we put there, we actually used the Southeast Second version printed out rather than the slip opinion, so the page numbers don't quite match up. So I did want to point out that if I'm referring to page numbers, it's to the Southeast Second, and the page numbers are very faint in the very bottom right-hand corner, and I apologize for how faint they are. I'm going to be able to abbreviate, I think, my argument some, which is I know you'll be very happy about. And I'd like to start with what Mr. Irvin and I agree on. And there's a lot that we agree on, which maybe will make this analysis easier. The first, we agree on that the fact, Mr. Irvin said, generally the facts are not in dispute. And that's important to think about where we are procedurally. That the facts are not in dispute. What you do have in this record is a very, very long verified complaint by the village, and then a very, very long verified response by Limited and Transportation. So you have sworn statements in the record in this docket. You also have the evidence that was presented and the commission's very detailed order in sub 21. That hearing went on, as I know Commissioner McKissick and Commissioner Hughes may have tried to drive it out of their minds, but that hearing went on for days and days and days, and that evidence is there. And at this point, the facts are not in dispute, but you have a lot of information before you to make policy decisions and make determinations. The other thing, Mr. Irvin,
Let me
yes.
question about that, Mr. Stires. Is there a policy decision before the commission, or is it a purely legal decision? Because I think that that's important.
I think there are legal issues, but there are policy determinations that we would like the commission to make regarding whether the commission has jurisdiction, and you do have jurisdiction, let me say, over aspects of the parking operation. That's not a dispute. So there's some threshold legal issues, but also there are policy decisions about what is appropriate for the level of regulation, and the commission, I think, can make that based on the record before it, can make that based upon your judgment, can make that based upon the statutes. And I think those policy determinations, not evidentiary, there's no facts in dispute. There's no need for an evidentiary hearing. You have all the briefs and filings that you have before you in this docket and other dockets. I think there are policy determinations that you can and should make in this docket at this time.
So, Mr. Stires, I want to make sure we're clear about that, because I think that we've been viewing this as a purely legal decision to be making a determination about the extent of regulation that the commission has based upon the Court of Appeals decision, and then possibly, if we accept the complainant's argument, the sub 22 order and the sub 21 order. So we have viewed it as a purely legal decision. It seems as if you have a different position about that, about a policy decision that could be made.
I think how the parking operations should and can be regulated is something that is before you squarely today on this record in this docket.
So to ask you the same question that we put to Mr. Irvin, how do you think it should work?
You've skipped ahead my 15 minutes to the argument to try to explain why I was going to get there. So reserving the time.
No, if you'd rather go through the preliminaries, feel free to do so.
I think
So, Mr. Stires, I think what we'll do, because we are keeping track of time, we will let you finish your oral argument, and then I do know that the commissioners will have some
and if
questions.
I don't answer it in my argument, make sure I still sit down before I do answer that, Commissioner Levitas. We also agree that the Court of Appeals decision controls. That's clear. Mr. Irvin used the term that said the parking facilities affect the ferry. rates. Subject to check, I counted 4 or 5 times. He kept saying the parking facilities affect fare service. Parking facilities affect fare service. And on that point, we agree. The parking facilities affect ferry service. The availability of that parking is absolutely something that's essential. We believe, we don't dispute that. And we think that's exactly what the Court of Appeals understood, and that is what they held. You know, and let me go to the Court of Appeals decision. There's a few points, a few areas we haven't talked about. And I'm not going to repeat the parts of the decision we have talked about. But the Court of Appeals decision is actually organized with a background, an analysis, and a conclusion. Now, on page 7 of the copy I gave to you, there's a final paragraph before the background that concludes the background section. And it says in the background, ultimately, these conclusions led the commission to order that the parking and barge operations and that are subject to the commission's jurisdiction and regulatory authority. And it goes and states the things that are the issues before them. And the last paragraph, again, this is highlighted on page 7 of what I provided to you. And finally, that BHI shall not sell, assign, pledge, or transfer the parking or barge operations without prior commission approval. So that's the conclusion of the background. So then it had the analysis. And I'm not going to go through a lot of the analysis because we've already discussed it, but I'm glad to answer any questions you may have on that. One word we did not talk about of the sections that have been subject to the commission's questions to Mr. Urban is when you've discussed the language, and I think this is on page 16 of the copy, when we talked about that the commission may be regulated, BHIL may be regulated as merely to the extent that its parking operations, and Mr. Levis is right, as an English major, that syntax is very odd. Also, the preceding highlighted paragraph, this authority extends only insofar as BHIL may be considered a public utility. Notice the verb there, and it's in passive tense to my English major friend up there. Not only does it says BHIL may be considered a utility or BHIL may be regulated. Let's change that to an active tense sentence. If it were written in an active tense, it would say this commission may regulate merely to the extent of the parking regulations impact. Or this commission may consider BHIL a public utility only to the extent of. So let's convert that sentence from passive tense to an active tense and it is discretionary to this commission, may, not shall. It's not obligatory. It's may. And what extent can you regulate? It is only to the extent that it affects parking, ferry rates or services. The last portion of the commission's of the Court of Appeals decision that I just want to highlight, we haven't discussed. I said there was a background, an analysis, and a conclusion. Well, let's go to the conclusion. Let's see what the court actually did say in the conclusion in the second sentence. Now, the commission properly concluded, this is what is affirmed, that it may, here we got it, the active tense, may regulate the sale of BHI's parking operations because BHI as parent utilizes the unregulated parking operations to service its wholly owned subsidiaries regulated ferry operations. So it identified 4 issues at the background. And then in the analysis, it said may regulate or BHI may be regulated to the extent. And in the end, it said, because we agree that it's the facility. And therefore, the Court of Appeals said you cannot sell that facility because the availability of that facility affects the ferry service. Beyond that, there is nothing in that Court of Appeals decision that talks about the regulation of rates by the parking. It's not addressed. It's not, it is not any way conferred to you that authority. Now, it doesn't say that you can regulate.
Excuse me,
I'm sorry.
are you not looking at the last sentence of the conclusion?
Okay, the last sentence of the conclusion. that we affirm the commission's order as to parking as modified within this opinion to clarify the statutory limitations of the commission's jurisdiction over BHIL and its parking operations. So I wasn't ignoring it, but clarifying to what degree, I guess, is maybe what what is the point. I'm now moving from what we agree on to what we disagree on.
Okay.
And you're right. And we're clear. So how is it clarifying? I think the key phrase, I think we've all sewn on this, is what does it mean to the extent that affects rates or services? And in that respect, I think it's important to maybe look at a little context and a little history. BHIL has adjusted parking rates multiple times over the past 30 years. I mean, this is nothing unusual. This is nothing that hasn't been done in the past. Since the early 1990s, BHIL has maintained parking first at Indigo and now at Deep Point. And for 30 years, it has provided notice in November if there was going to be a parking increase and with an effective date of January 1. And the ferry service continues just as the ferry service has always been provided. In fact, in 2019, BHIL eliminated an entire class of rates, what was called the general daily parking, and replaced it with a 90-day exit pass for contractors. Why did they do that? And why didn't anyone complain to the commission about them doing away with the whole rate class? Well, because before that rate class, the daily rate the contractors were to pay during off-season was $9 a day. They did away with that rate and replaced it with the 90-day exit pass, after which the daily rate for contractors off-season exit was $5 a day. But it did away with a whole rate class and instituted a whole rate class because it was the right thing to do, that working with contractors during the off-season. So the changes to the rates have occurred regularly over the past 30 years. There's nothing unusual about it. Before the parking rates were changed, the ferry rates were the same. They were the same prior to 2010. Then they were set in the new rate case in 2010, and the ferry rates did not change every time those parking rates changed. There was no effect on the ferry rates. Then before and after those parking rates were adjusted, the ferry service was the same before the parking rates were adjusted as it was after the parking rates adjusted. And so there was no effect on the ferry service. Now, I know that the village disputes. Now we're moving to what we disagree on. The village disputes that. So sometimes I will revert to what I remember my grandmother saying when I was very, very young. And she said, you know, the best way to find out whether it's raining outside is to go outside and see if you get wet. If you go outside and you don't get wet, it's probably not raining. If you get wet, it probably is raining. In other words, what were the consequences of those parking adjustments over the past 30 years? What was the actual effect? Not hypothetical, not speculative, not theoretical, but what was the effect when the parking rates were increased on a regular basis? Well, regarding the parking at the Deep Point Terminal, those inflation-based increases were being made periodically, as we've shown, I think, in Exhibit 3 to our response. There were no customer complaints to the public staff or the commission. In fact, there's never been, to our knowledge, a customer complaint other than when the village itself, who wants to buy the system, has filed its complaints before the commission here. Service was maintained at its very high level of quality. Ridership continues to increase year over year. It has the same management, same captains, same operating officer. There was no effect on the ferry service. And you may ask, why? Why hasn't there an effect? You've made these adjustments over all these years, and the answer is fairly simple. And it was found by this commission that the rates are, as this commission found in the sub 22 order, reasonable. That is a finding number 35 in the sub 22 order, which is the last document attached there behind tab 8, page 8 and 9. finding 35, with respect to the parking and the barge operations, the rates of BHIL is currently charging for parking are reasonable and should be allowed to continue, consistent with the sub 21 order. And why, and reasonable, well, it talks in finding 43 that this commission made, with regards to Sharp View, but also applies now to BHIL, has significant incentive to maintain reasonable rates and provide high quality service in order to increase asset and operational utilization. Because it's investment in, because you got a fixed asset there and you're going to want to have folks parking there to utilize that fixed asset. So that's why rates have been reasonable and that's why rates are reasonable.
Okay. So, Mr. Cyrus, let me interrupt. Do you take the position though? So your argument is that the notice and the increase was just was an inflationary adjustment.
Mhm.
Do you take the position, because you did say that you could, that that limited could increase rates in excess of the the rate of inflation without, I believe you said without commission approval. Do you still take that position? What is your position? Is limited to any increases just to the rate of inflation, or if you had capital investments, or in your view, other reasons to increase the rates, do you believe that you are permitted to provide notice to the commission and unilaterally increase rates in excess of the inflationary adjustment?
I'll answer your question and Mr. Levis's former question at the same answer. And then if I may explain why. The answer is, yeah, that as has been done for the last 30 years, as is the status quo that was preserved by the sub 21 order, the HIL can increase rates at or below the rate of inflation to maintain the real dollars of the cost of parking. So that it doesn't have to come back in here for a rate case, and we know how controversial this always are.
Mhm.
So long as they stay below the rate of inflation, that is in fact been the status quo. That has been the practice. That has been what's worked. And I'll talk about finding the commission in sub 21 in a moment. If BHIL made substantial capital improvements and investments and otherwise needed to increase rates more than the rate of inflation, then it would need to come back and ask the commission for approval of that. That, I believe, is an appropriate mechanism to answer Ms. Levis's question. Now, you should be able to monitor the increases. And that's why, for the first time ever, in light of the sub 21 order, we filed notice to the commission, filed it in this docket, so you and the public staff could monitor what those rates were. In the past, the commission had no idea what the rates were. Public staff really didn't know what the rates were. They were never filed. So we think that we are obligated to provide notice. You have an obligation. You have the right to have us come in for a show cause hearing. You have a right to make us come in to your own sua sponte motion, or the public staff representing the using consuming public. But so long as we maintain the status quo, which is to increase rates no greater than the rate of inflation to maintain the real purchase power of the prices, then we think that that is something that was permitted, allowed both by commission order and the Court of Appeals.
So, Mr. Cyrus, I think then what I'm hearing from you is you, in essence, agree with the complainants that the Court of Appeals order is not the authority of the commission is not for the parking, for limited parking rates, is not limited solely to the context of the sale of the parking operations. You are agreeing with the complainants that, if I'm understanding your argument correctly, that if the rates have an impact on the rates or services of transportation's ferry operations, then the commission has jurisdiction and authority over limited parking rates. Is that correct?
I think that's what the Court of Appeals says. It's to the extent it has an effect on parking service or rates.
And who has in that situation, where does the burden lie? Who has the burden for arguing or taking the position that the increase in parking rates do in fact impact the rates or services of the ferry operations?
Okay, so if I can back up just a second, give you some background in answering that question. In the sub 21 hearing, lots of testimony, it went on for days, and as the commission recited in its order at page 28, that is not to say the status quo must immediately change, citing the president of the Bald Head Island Association, Briggs, quote, "We have a good deal there. There's no question it's reasonable." The commission went on to say, "No party has asked this commission to initiate a general rate proceeding, and the great weight of the evidence shows that at present, the parties are generally satisfied with the current rates and services of both BHIL and BHIT, as well as the agreement that they struck in the last general rate case." Let me repeat that. As well as the agreement that they struck in the last general rate case involving the parking operations. So what's the agreement that was struck in the last rate case that still applies? It's that, parking can be increased up to the rate of inflation. And to the extent that all we're doing is preserving in real terms the cost of parking there, then I think at that point, the burden should be, to answer your question, because I haven't forgotten, Chair Kimwright, to answer your question, so long as all we're doing is preserving in real dollars by keeping it below the rate of inflation, then the burden would be on someone else to come in here and make it, which again, the public staff can do on behalf of the using consuming public, commission could do on its own sua sponte, could come in, or our customer who's using it could come in and file a complaint that the keeping up with the rate of inflation was not just and reasonable, and the burden would be on that complainant.
Yeah, and so thank you, Mr. Cyrus, but I have a question about the last rate case that you're referring to. I believe that's A-41 sub 7.
Correct.
And there was a stipulation and agreement dated October 21 of 2010 that was referenced in the
Correct.
rate case order. And in that stipulation, Limited agreed not to increase the parking rates in an amount greater than the percentage change in inflation, but that agreement was applicable only until December 31st of 2016. So how is that agreement still applicable? Because you referenced that you're continuing to abide by the procedures and the requirements of the last rate case, which was the A-41 sub 7 proceeding.
You are correct. That having been said, the aggregate increase, compound aggregate increase in parking rates since the rate case in 2011 have been less than the rate of inflation during that period. We've never exceeded that. So we have unilaterally decided on our own not to increase it more than the rate of inflation. And then Chartview has agreed to be bound by that going forward. The commission has the authority in this docket, in the order coming out of this hearing, to say, so long as the rates do not increase greater than the rate of inflation, to preserve the real dollar amount of the prices for parking, then that you could order that in this docket, and we would consent to that.
Did I understand you to say that in the event of a proposed rate increase greater than the rate of inflation, that you would concede that a general rate case would have to be initiated by Limited or its successor?
That we would have to come in and ask for commission approval and make and demonstrate why that was justified. What I do not agree that would be a general rate case to set a rate of return.
Fair enough. I appreciate the
Yes,
distinction.
that's correct. That would be our position. That's correct. And let me talk a little bit about.
Mr. Stires, we are coming to the end of your oral argument time. We have asked a lot of questions, but I'll give you an opportunity to conclude and wrap it up.
If I may have just about 2 minutes, 2 or 3 minutes, I think so. I will conclude it this way, and it also follows up. Of course, the practical effect of the allowed inflation-based increase is simply to maintain the rates in real terms after inflation without requiring a commission hearing to approve each one of those rate cases. And let me explain why, in my concluding remarks, why that's so important. Parking is not regulated by this commission anywhere else in the state. It's not regulated by any commission anywhere in the country under any circumstances. If you look at the NARUC standard of accounts, there's no category for parking, assets or revenue or income. I mean, there's no cases, there's no examples. So therefore, if we came in for a general rate case, it would raise a whole host of hotly contested and unknown and unknowable issues like rate of return, rate base, used and useful, and other issues that are both inapplicable and, quite frankly, unnecessary in the context of a parking operation. That is implicitly, I think Commissioner McKissick was looking at that sub 21 order. That was implicit in that order that the commission did not want to go there. If I'm not mistaken, they realized that's not where they wanted to go. And if it's explicit, if you read the sub 21 and sub 22 Court of Appeals decisions in tandem, I will say in the sub 22 appeal, the village's exceptions to listed that the commission did not have authority to approve rate of inflation increases. They briefed it and said the commission did not have authority to approve rate of inflation increases. They argued it at the Court of Appeals that you did not have that authority, and the Court of Appeals affirmed your decision with the rate of inflation increases sub 22. So that was argued, and the Court of Appeals found, as a matter of law, you do have that authority in its sub 22 order. So, so if you read that together, it says, in totality, inflation adjustments are allowed so long as they continue at that level, because if they are allowed and the current rates are reasonable, then there's no effect. There can be, if it's currently reasonable now and the rates are set, then there's no effect on rates of service. Finally, beyond all these legal issues, and you've heard us lawyers make a lot of legal arguments, there's also the practical note considering I'd like to leave with you in conclusion. This is how parking rates have been adjusted for 30 years without approval or out with even notice. BHL has had and still has the same business incentive that the commission recognized in its finding 43 in the sub 22 order, that the owner of the parking has the quote, significant incentive to maintain reasonable rates and provide high quality service. Therefore, in light of the commission's statement in its own sub 21 order that quote, it is generally guided by the principle that its authority only need to be imposed to achieve the purpose of the regulation, only where needed, close quote. Here, there's not only no legal authority, there's no need to regulate parking rates. And if there's no need, then the other practical consideration is this. For a parking lot next to a terminal from which a passenger ferry serves a small island off the coast of Brunswick County, for residents and visitors who choose to live or visit there by their choice, how much of this commission's and the public staff's time, attention, and energy should be devoted to regulating the rates of a parking lot?
Okay. Thank you, Mr. Cyrus.
Thank you very much.
I have just a couple of questions for you, and then I'll look to my fellow commissioners. In regard to the rate adjustment, is there information that was provided to the commission that demonstrates that it is in fact an I'm mispronouncing it, an adjustment for inflation, and is solely limited to an inflation adjustment? Is there evidence
Yes.
to demonstrate that?
Yes, that is in the notebook I handed to you behind tab C, which is our response
Okay.
3 of the verified complaint by Mr. Paul, who himself ran those numbers. And if you want to put him under oath, he is here and could testify under oath. He doesn't need to because it is verified.
Mhm.
And the math is the math. The derivation of the rate of inflation is obvious in that chart. And you can look at the derivation of the inflation rates. You can look at how rates have increased since the last rate case, and the math speaks for itself and can be found by this commission. And it's not refuted because it can't be refuted.
And Mr. Cyrus, want to ask a couple questions about the timing for providing notice and then putting the rate increase into effect. And so there was essentially about a 2-month period. Notice was provided, and then about approximately 2 months later, the increased rates went into effect. And in the sub 22 proceeding and in the sub 22 order, there was a stipulation and settlement agreement that included regulatory conditions. And the regulatory conditions, I recognize, are not effective at this point because the sale of the ferry has not closed and has not happened.
Correct.
But nonetheless, the spirit of that agreement, can you explain why the regulatory conditions stated that Limited would provide 3 months notice of any increase in the rates for parking? Why did you not comply with the spirit of those regulatory conditions?
That's a great question. So subject to check, the sub 21 order came down in October of last year. And again, and Ms. Hedrick's going to correct me if I'm wrong, and could give me the dates. Subject check will be in October. And we felt that it was very clear that because the commission's authority was limited to the extent that it affects rates and services, and because the parking rates do not affect rates or services, that we felt we were clear under sub 21 to continue the status quo and to make the continued changes. We knew, however, that the village had argued at the Court of Appeals in sub 22 that you didn't have the authority and it was improper to allow inflation adjusted increases. Condition 5 was the subject of the appeal. We didn't get that order until November, if I'm not mistaken. So early November. So to the extent that we got the green light from the Court of Appeals to adjust rates, and then we got the green light from the Court of Appeals in the sub 22 that it was okay to adjust them up to the rate of inflation, that provision was proper, and that you have that mechanism, and that is the law, even though there is a petition for discretionary review, believe it or not, of that per curiam unanimous decision. We waited until we made sure we were clear legally on both of those. The second point was that that's how we'd always done it, and that's what people were used to. People were accustomed to getting their notice in November, and being notified, and the mayor and the council and everyone on the island who has an annual parking rate knows to pay those annual parking passes in December to take effect in January 1, which is the calendar year financing for Bald Head Island Limited. So in retrospect, would I have liked to have given 3 months? Yes. As a practical matter, we wanted to make sure that we were on all 4 square solid grounds with the Court of Appeals decisions in sub 21 and sub 22 before we did anything. But from an accounting perspective, from an administrative perspective, from a customer expectation perspective, they take effect on January 1. And that's how the timing came out the way that it did.
Mm-hmm. And you mentioned something about, you referenced the status quo. The village has argued that the sub 21 order requires Limited to maintain the status quo pending further order by the commission. Did you violate that status quo by even adjusting for the rate of inflation on January the 1st of 2025?
No, because the status quo, what we've been done for the last 30 years and what we've been allowed to do, and what we needed to do, and I'll go to that in just a moment, was to make changes less than the rate of inflation. I believe that if we had made a large increase, something that other than what the village itself describes as modest, then I think we would have been on thin ice. But I think given the history, given the practice, given customer expectations, and given the fact that the commission knew that the status quo had involved the rate case order, which allowed increases, that we were consistent with the status quo. It's interesting they weren't to use the word status quo. I mean, they could have said, do not change your rates. That's not in the sub 21 order. They said, maintain the status quo. I don't want to sound like I'm quibbling. I get it. I mean, word choice. Authors have to choose between words, but the status quo had involved continuing to adjust the rates over time. So that's why we did not violate the status quo.
And just a couple more questions. So the village is arguing that any increase, that the Court of Appeals and has already determined that that the parking rates affect or impact the rates or services of the ferry operations. And so any increase, even if it's to the rate of inflation, is required to come before the commission and to be approved by the commission. How do you respond to that, since you are agreeing that the commission does have jurisdiction and authority over the rates of the parking operations?
I'd like to respond to it in two different ways. The first is, people make allegations and conclusions all the time. But as I think Mr. Levitt alluded to in one of his earlier questions, Mr. Urban, where's the evidence? Where is there some indication, given the commission has found that the parking rates are reasonable, given the commission has found both in sub 7 and sub 22 that increases by rate of inflation to maintain real purchasing power of the rates are the same, where is the effect that you're even alleging here? There is not, to my knowledge, subject to check in the complaint anywhere that says this has an effect on parking service rates. It says it's not proper. It's presumptively not just and reasonable. So that's my first. This is an allegation. And if that's all it takes to haul us in here to the commission for a docket, that is not what I don't think this commission should be focused on or allow those types of unsupported allegations. The second point, and for those who've been around as long as I have in this room, and I told Mr. Watson I would call him out since this is one of his last hearings. He's been around long enough to know this too. There's been an inordinate amount of litigation involving the Bald Head Island Ferry. And while it may be against my personal self-interest, it needs to come to a stop. We ask the commission to succinctly, decisively say, enough is enough. Establish the state and order the very limited role of oversight that you have for both BHIL and for its buyer, so they know what they need to do and they do it. But enough is enough. And they have to come in here every time we make adjustments, such as lowering contractor rate from $9 to $5 for the off season, like we did in 2019, to have to come in every single time and go through an intervention and being contested. That is not a good administrative regulatory paradigm for us to continue in this matter. A very limited scope. You have the authority. You have the authority to bring us in on a show cause hearing. If you think it's unreasonable, you want us to come in and explain why we've adjusted rates, you can do that. I don't have a problem with that.
Well, so Mr. Chaz, I just want to make sure I'm fully clear on what Limited will be doing going forward, or what your position that Limited will do. If it is any amount, even a de minimis amount above the inflation adjustment for inflation, will Limited request approval from the commission for any amount above that, and without having to have some party come in and make an allegation or determination that it does affect the rates or services of the ferry operations?
This is kind of my answer to Mr. Levitt's very first question. Yes, we believe that would be appropriate, and we would agree to that.
Okay. And last question is related to something we haven't really talked about during oral argument, is the audit. The village has asked that the commission order an audit in this proceeding. And they referenced that in the last rate case, the A-41 sub 7 rate case, that the public staff had agreed to perform an audit. There were some conditions to when the audit would be conducted. Has that audit ever occurred? And if it's not, why has it not occurred?
It is not. And the reason is that when it was going to come up, Mr. Mitchell had died. As you've heard me say before, it's like the first line from the Charles Dickens Christmas Carol, Marley is dead. Mr. Mitchell died now 12 years ago, and we've been trying to dispose of this asset. In 2015-16, when that audit was to occur, we had legislation that had been passed by the General Assembly and a creation of the Baltimore Island Authority, supported by the village, to purchase the ferry. And that was going to be a non-jurisdictional public entity. And that was teed up and ready to go. And the public staff knew that. And the public staff said, there's no reason for us to perform the audit. This is going to be sold. Mr. Mitchell is dead. It's going to go to an entity. And so the public staff decided, why use our resources when there's going to be a sale to an exempt entity and we're not going to need to do the audit? And therefore, the audit never occurred. Because the village stepped in, opposed that sale and the financing was not approved because of the village's opposition at the local government commission, and so that sale fell through. We are, however, at the same point today. We are prepared to close and sell to Sharpview with the conditions, 24 conditions, 48 conditions that the commission imposed, including limitations on parking increases and limitations on ferry increases. And the conditions are in place. The conditions have been affirmed by the Court of Appeals, and we're at the same place that we were then. We're ready to sell. And all that means is that the audit would be for what purpose? Because you've already made the determination in sub 22 that the sale of Sharpview with those conditions on limitations of rate increases are going to be imposed on Sharpview. And all we're waiting for is for the litigation to come to an end.
Okay. Thank you, Mr. Sayers. Let me check to see if there's any questions from the commissioners. Commissioner Levitas.
So to that point, what is exactly interfering with the closing of the sale?
So the sub 22 approval of the transfer was unanimously approved in a per curiam unpublished decision by the Court of Appeals. The village filed a PDR to the Supreme Court asking them to review that unpublished per curiam decision. There is a piece of paper that was purported to be a right of first refusal that the village would not release. And therefore, we had to file an action to get that invalidated by the Brunswick County Superior Court. The senior Superior Court judge in Brunswick County found that that was not valid, not on one, but two independent grounds. One was that the village had been given an offer to purchase it at the same terms as Sharpview, and it decided to exercise not to purchase it. The Court of Appeals has issued an order under 30F that it will decide that case without the need for oral arguments. They met in conference on April 8th, and we are now awaiting a decision. So as soon as those two pieces of litigation are concluded, then the sale can close.
But you, I think, imply in your pleadings that this proceeding is interfering with the sale. Is that?
It's not
case?
preventing the sale, but litigation creates uncertainty. Buyers don't like not knowing exactly what the regulatory environment is of the assets that they're purchasing. So this is not preventing the sale. This is not,
Okay.
but it is increasing the uncertainty. And the longer this drags out, the greater that uncertainty continues. And how are they budgeting their litigation expense and their projected costs going forward? So that's why enough is enough. It needs to come to an end.
Okay, thank you for that. So the village, in their reply, suggests that it would be inappropriate to dispose of this matter on a motion to dismiss, that there are matters that are more properly deferred to a development of record and so forth. Given that you have now agreed that were there to be an increase greater than the rate of inflation, then, and, and if the village were to have alleged that this increase were greater than the rate of inflation, then I assume you agree that a motion to dismiss would be inappropriate.
Yeah, I think so. At that
Okay.
point.
But I believe in response to Chair Kimmeright's question, Mr. Irvin said they haven't in fact alleged an increase greater than the rate of inflation. Is that,
That is not my recollection complaint.
okay, that's all I have. Thank you.
They alleged that it, and I think, I mean, I don't think Mr. Irvin said that. I mean, let me say that. He said that he believed that they were not, he did not concede that they were just and unreasonable because they weren't approved by this commission. They were presumptively not just and reasonable. He said he had not done the math. So I don't think he said that it was not within the rate of inflation. So I don't want to put words in his mouth.
Okay, well, maybe we'll have a chance to ask him about that.
Thank you, Mr. Cyrus. You may step down, and now we will hear 5 minutes of rebuttal from the complainant. Mhm. And we will take a 2-minute break to switch the microphones around.
I was going to say, if Mr. Stires does not mind my coming over to his side of the room, we can avoid switching everything around.
I think that would be great.
That way I can be accused of talking out of multiple sides of my mouth at the same time. The other thing is that my friend Mr. Stires is much taller than me, so let me get the mic position properly. Can everybody hear me? Okay. In light of Mr. Stires, what I understood to be Mr. Stires' concession that the commission does in fact have authority over rate changes in excess of the rate of inflation. I don't want to spend any further time talking about that type of rate proceeding because it sounds to me as if we may have had at least agreement to that extent in this proceeding. So let me talk a little bit about what he says his client can still do. And let me explain why we are not willing to agree to that in this case. In essence, we do not believe that a process like what Mr. Stires has described maintains the status quo, because as we discussed in some detail earlier, the status quo is the sub 21 order said you can charge these rates, period. The idea that the status quo goes back and picks up a process that expired in 2016 or some ordinary course practice that's not mentioned anywhere in the commission's order, it seems to me is, don't think you should find that to be persuasive. Instead, it seems to me, even with respect to increases that are within the rate of inflation, at least, I'm not going to concede the authority of the commission to do that, certainly not in this proceeding. If the commission, after having had an appropriate rate proceeding initiated by a petition or motion that has been properly filed with the commission, if the commission wants to adopt such a proceeding, we can litigate that at that time. I do think there's got to be some requirement or some showing on the part of BHIT and BHIL that a rate of inflation-based adjustment properly reflects the cost that are being incurred for parking. We've all just assumed, not we haven't assumed that, but the assumption has been that that's an appropriate way to do it. They've never come in and shown that the general rate of inflation has much bearing on the cost that they suggest. They could be different. We don't know. The burden should be on them to make that showing.
So, Mr. Irvin, one question about that, about the status quo.
Yes, ma'am.
Could the status quo, so the sub 21 order did require Limited to maintain the status quo pending a further order of the commission. Could that statement by the commission be interpreted to reference status quo of the historical practice of increasing increasing rates just by the rate of inflation?
I don't believe so. There's certainly nothing. Again, that's a long order and I don't have it committed to memory, but I don't remember anything in the order that discusses any kind of pattern or practice over some period of time. It actually goes back and refers to the 2010 rate order, which is, we've already discussed, expired in 2016. So no, I don't believe I can agree to that. You know, at the end of the day, what we're talking about is the protection of the consuming public. And we still continue to believe that a number of things need to be done. I don't think that the pending sale to Sharpview should absolve anybody from performing the audit. If the idea was we're not going to have an audit because it's going to go to a non-regulated exempt entity, that's one thing. Sharpview is not an unregulated exempt entity. This commission, if that transaction is ever closed, and I believe there's one other thing that's got to happen before that closure can occur, which is that the commission has to approve some affiliate contracts, at least as far as I know, haven't been filed with the commission yet. What the status of any negotiations between the company and the public staff may be, I don't know. But there's that third issue there as well. But we need the audit because that permits us to make some determinations about what is just and what is reasonable. And I think the commission would want to know that. It ordered it when this was still in a regulated environment in 2010. It's still in a regulated environment. And so I think
Excuse me,
we need to do that.
Mr. Irvin, so I realize that your complaint is premised on sort of a different interpretation or particular interpretation of the Court of Appeals decision and what you think the law is and how this process should work. But to the question I should have put to you to begin with, as to whether you contend that this rate increase exceeds the rate of inflation. I don't think that allegation is made in the complaint. Is that right?
I don't believe, I believe Mr. Stires is correct at I think his description of my earlier answer was correct one, that I haven't done the calculation. I don't know that. I'm not
Right.
arguing to the contrary. I just don't know. Plus, I think there needs to be some evidence. There needs to be a filing. There needs to be a showing. And none of that's been done yet.
Well, I understand that's how you think it should work.
Yeah.
But if we were to agree with Mr. Stires that rate increases at or below the rate of inflation do not require approval by this commission, wouldn't it then be incumbent upon you or some other party to come before us and allege that there had been an increase that exceeded the rate of inflation and not been properly considered by us?
I think if they knew that this increase was greater than the rate of inflation, even under that hypothesis, they would be obligated to come forward and make such.
Fair enough. But if they believe that it's not and somebody disagrees, doesn't that party need to come before us and allege subject to Rule 11 considerations that they have some reasonable basis to believe that the rate increase does exceed the rate of
Well, I think
inflation?
if that was the procedure that the commission approved and it withstood any appeal, then yes, I mean, I think that if that's what you said, that's what we'd have to do. I'm contending, however, that that's not what you should do.
I understand. Thank you.
And so that's probably not a direct answer to your question, but it's the best I can do.
Thank you.
Ultimately, at the end of the day, I don't have any question, but that I'm sure the commission is tired of hearing litigation on this subject. But I would say that one of the reasons is because the customers of this company, as represented by the village, are concerned about the cost that they pay for the service. They are concerned about its continued viability and do not apologize for exercising the legal rights that are available to them. The fact that litigation has existed is unfortunate. But as Commissioner Brawley asked me about, just as an example, this was initiated without even any discussion in front of us. A collaborative process works a whole lot better than the kind of process that we've used, but this is the process that we've used. I would ask the commission to rule, as we have requested earlier, to strike the notice, require if BHIT and BHIL wish to proceed, with this rate increase, that they do so in a proper manner, set that matter for evidentiary hearing, decide how you want to go, and then rule on the basis of an evidentiary record, not on assumptions as to what cost changes might be. And so we appreciate the time and the patience that you've shown today. Thank you for your consideration, and I ask you to rule in that manner.
Thank you, Mr. Irvin, and thank you to Mr. Irvin and Mr. Sires and the attorneys for the excellent oral arguments that were presented today, along with the filings that were made that were very helpful and informative. As I remind the parties that proposed orders are due no later than June the 6th of 2025. Are there any additional matters or concerns with the process for the orders that need to be addressed before we adjourn? Mr. Sires?
Yes, thank you, Mr. Chair. Commissioner Kimwright, my client has expressed some concern that perhaps my remarks have been interpreted as to saying that we would consent to some type of standard rate case if there was ever an increase that went over and above the rate of inflation. And I don't want to leave the commission that impression. If that was the impression that you took, we will clarify that in our proposed order. So in the proposed order, I did not want to leave the impression that if we had capital expenditures, if we could demonstrate to the commission with our burden that we would have to go through a full-blown rate case. And I did not want my former remarks to be interpreted in that way. And my client was concerned that perhaps I had left you that impression.
Thank you for the clarification.
And may I just say, since it was in response to my question, and I used the term general rate case, and you corrected me and said, because I was asking about your concession, and you stated that what you were referring to was some form of approval by this commission other than a general rate case. So I think you were very clear about that.
And I don't think that the commission has to decide that now, and we'll cross that bridge whenever we get to it, if we get to it. But, so I just did not want that to be in the record, that we would believe that would be the right process, given the unique nature of this asset.
Okay. Thank you, Mr. Sires. Are there any additional matters that need to be addressed? So proposed orders are due on June the 6th, 2025, and the hearing is adjourned. Thank you.